Honorable members, I guess let me greet you. Can we try and wait? I don't know how long we must wait for logins to make a determination.
Let's give it another 2 or 3 minutes, Chair, because we need another member to proceed at least.
We need one member.
Yeah, there's 4 members in now, but we need one to continue with the meeting.
Yeah. Molo Tatu Mailem.
Molo, Chair.
Are you good?
Yeah, I'm a bit tired after last night, Chair.
Yeah, you are giving us marathons these days. Siswiti. Maybe it's still on air. Sis Valencia. I think we are.
We are 5 now, yeah. Yes, Chair.
Okay. Guide us, please. Where do we start? Let me welcome honorable members. I know it's an awkward situation for members. We don't usually meet on a Thursday. Usually, it's a normal sitting of the House. If not normal sitting, it will be for some members a traveling day. So we know that it's an anomaly that we're doing, but unfortunately, as we know, we've got a task in hand. Members might find us on the way. Ari, can I take any apologies?
We've just received the one apology, Chair, from Honorable Mahluale, who's currently flying out. He'll only be joining us at 3 o'clock, Chair. Those are the only apologies received.
Okay.
Sorry, Chair. Also, Honorable Volmarans is also flying out. He will join us soon. Thank you.
Okay. On that note, without any delays, where do we start, Ari? Do we start on the recap of the outstanding matters, or we deal with try and finalize the period, the process, and then probably come back with the recap? I'm just looking at the best or better process or procedure. I know there were issues that we left that they must be packed. Shouldn't we just do And whilst members, I saw the response from legal services. Shouldn't we allow members to go through all those issues that was supposed to deal with and then come back to recap? I just need procedural guidance from yourselves, including legal services and the state law advisor, as well as my honorable members. I don't think it's a long issue. It's just to get guidance. Maybe let me start with the legal minds, Raksha, and
Recording in progress.
And Frank, so that you are comfortable, you speak better.
Chairperson, if I may, first of all, my apologies for missing yesterday's meeting. I had some family obligations to take my daughter to doctor. So I did get the question that the members were considering during that deliberations and discussed it with Raksha, the state law advisor. And the result is that paper before you, Chair. My view on it, Chair, I think we are at clause 5 of the bill, and we can continue with that. If there are questions on our input on those definitions, Chair, I'm here. We can take them, but just shortly, all we did with that paper is try to point out the process of getting to those two definitions, and if they're not clear, Chair, I think what I did in that paper, Chair, and that's pretty evident, is to see what context those words are used in. So if the words are not clear as they are defined now, and members can keep that paper with them, then obviously we can come back to those definitions. If they work when we go through the body of the bill, then it's good. And the same with the view on those powers. The powers of NERSA, the regulator, Chair, as I've indicated, it did shift from having both regulatory powers over the pricing and tariffs, and then the amendment proposed, the bill has introduced, my apologies, appears to want to limit it just to tariffs, but because of the public participation and the public comments, it's gone to where it is at the moment, where they have the authority to deal with both pricing and tariffs. And there again, I try to put that in context. When do we use tariff and when do we use price? But that's just, Chair, it's one legal mind or one group of legal minds. There's, of course, always another hand, as the lawyers say. So, Chair, I suggest that if there are issues with our advice, or questions, we can deal with those. But perhaps it's good to see how the definitions work within the body of the bill and to get into that to see if there are any issues that we sort of have to reverse engineer and get clarity on, Chairperson. Thank you.
Okay, can we, I think on that note, can we proceed and deal with the rest? Because there might be a point where we need to make a determination only when we are fully constituted. I would suggest that let's proceed like we were proceeding yesterday, and then we will try and do a recap. Depending how far we go, we'll do the recap, and then we must keep the proposed advices. And as you say, Advocate Jenkins, where there is a situation where those issues emerges, we will then try to manage those until we are able to finalize what is the context that we finally agree on. If we agree on that note, Ari, can we then go back where we ended yesterday?
We're supposed to proceed on page 7, Chair, of the bill.
On G.
Yes, Chair.
Is there an issue from the version of the comments? I don't want to say of the department only. On the
No,
comment.
Chair.
There's no comment. Honorable members, there a tick that you want to have. Let's go back to that G. If there's no comment, let's go back to that G. we just have to deal with the context. The G in the main is in the main on the, I think we have dealt with this before. So let's say the amendment is we said is the underlined one, ne? So where it says with the substitution for paragraph B of the following paragraph, it means we add and arbitrate. Am I correct? My interpretation?
Correct, Chair.
Okay. There it is, Honorable Milam.
Chairperson, I just want to remind you that the word resellers was inserted into that 4B1. So it would be distributors, resellers, traders, the transmission system operator, etc., etc.
I think I want to say you are correct, Honorable Milam. Let's check also with DMRE and legal services and factory. Is then will you have an issue? Will you have an issue putting us?
Yes. Yes, Honorable Chair. Thank you. Good afternoon, Honorable Chair and Honorable members. Yes, it is as on the column document, Ari, it's there, the insertion of resellers. There we go, yes.
Oh, is it this one?
Yes.
Oh.
With the blue, yes. Thank you, Honorable Chair.
Okay, sorry for not greeting you, DMRE. Don't say I woke up with an attitude. Sorry. Good afternoon to you also. Okay, I think Honorable Milam, there's agreement.
Chair, could
we
ask Ari to make that one a little bit bigger? I'm struggling to read it here. Thank you, Chair.
You want a bigger font?
Thank you.
Yeah,
They're fine, Mr. Milam.
Thank you very much.
Okay. Can we then go which one beside that, Ari?
I see there's 4B2 as well, Chair.
4B2?
Yeah, the proposals are supported. Proposed to be amended.
Oh.
Chair, this was where we ended yesterday, and this was what provoked the discussion about prices and tariffs. And if I may, Chair, it comes back to what Advocate Jenkins has identified in his letter. I take what the initial intent was of the act, and I think that we're perhaps venturing into waters that are best left unmuddied when we insert prices into the regulation there to set and regulate prices. The reason being, as identified by Advocate Jenkins, that NERSA had a real difficulty in actually doing that side of it, doing the demand side setting of prices, and that they were primarily focused on generation or supply side tariffs rather than demand side prices. So I think we might be creating a problem for ourselves if we say set and regulate prices. Thank you.
That's why I said, can we park the actual part, because that one is an issue whether there is agreement or disagreement. I think the main problem was that also, what is our understanding or common understanding of the word price and the issue of the tariffs, and if we agree on the interpretation of the tariffs, and the prices, it will then be up to us, like you say, whether, like you say, that we are asking NERSA to enter a territory that might be beyond their scope. But when I read, that's why I was saying when we come back, when I read, there was also an element that said maybe we can live with the issue of the regulation, but setting the prices. And when I read the contextually, it also raises that question whether you want NERSA to set prices or you want NERSA, even in that environment, if there's agreement, to do regulation instead of setting prices. So I was just saying, can we park that so that it becomes part of what, when we deal with clause that clause, is it something that we agree or is it something that we disagree? I don't know whether that won't help us going forward.
Chair, I'm happy to park it for now.
Okay, Honorable Malinga.
No. Greetings to yourself, Chairperson, and honorable members and everybody on the call. Unfortunately, I'm also on the road, Chair. I was going to say, let's pack it, Chairperson, for further discussion, because I have a different view than what is being presented here. So I'm okay with packing the issue. Thank you very much, Chair.
Okay, thank you, honorable members. Now we will deal with it. It's not going to disappear. We will first have to finalize our definition, then at the same time, look at the context and the meaning and the sense of it. Can we now go to Ari?
Section 6, Chair.
Oh. What is there a comment on the department or the public?
No, Chair.
Can you go back there? No, the original proposed amendment on this. Yes, maybe you can help us, DMRE, so that we can help. It says the regulator may require a license to establish and fund a customer or end users. By the way, I would say end user and then put in bracket the S instead, because it says end users, but you say a customer, not customers. Or we just leave it end user. If it's a plural at that time, then it is being treated as a plural. And then it says, or end users forum. Oh, okay, now I see. End users forum in the manner set out in the license held by such a person. Now, where I see there is a flexibility, just help us. Why do we need to be flexible and not be certain or be determined? Like using, why do we choose may and not must, or should, or can? Marie?
Yes, Honorable Chair. So the thinking behind this was that if we say must, then it's obligatory. Whereas if we say may, then it's discretionary, which allows the regulator to look at it on a case-by-case basis as well. Thank you, Chair.
Okay, that's fine. Let's leave it. Okay, I hope we are clear, honorable members. Can we go to the next?
Okay, just quickly, section 4A.
Okay, sorry, Honorable Malinga.
No. Thank you very much again, Chairperson. I don't want to dispute the explanation from the department, but remember, Chairperson, we are making a law here. So if we are giving leverage as to obligatory or discretion, what is it that we want to achieve with this clause actually on the bill? Because if we say the regulator may assist or a customer or customers and end users using their discretion, or what is it that really we are saying here? Maybe if I could get, if DDG Wabe can further elaborate on that one so that I understand that the discretion, who determines the discretion? Is it the regulator or the situation? Thank you very much, Chair.
Yes, Honorable Chair. Mr. Nhlapo will elaborate, Honorable Chair.
Thank you, Chair, and good afternoon to the honorable members and the teams. Honorable member, it's the regulator who has to exercise the discretion, and then what is sought to be achieved was that when the regulator determines license conditions, they look at on a case-by-case basis, they look at what best license conditions are suitable for particular circumstances. So that provision, when it said must, even in circumstances where that scenario was not prevailing or would not prevail, the regulator would be forced to set up a license condition that covers that, even if they are of the view that maybe this does not apply in the circumstance. So the proposal was that when we introduce may, then the regulator can differentiate the requirements as per the different circumstances that prevail when they set license conditions for the different applicants. Thank you, Chair.
Okay, let me have this understanding. Who may require a license? Because it says here, the regulator may require a license to establish and fund a customer. Now, from where I'm reading, it says, I'm the regulator, but in order for me as a regulator to establish and fund a customer or end user forum, I would require a license as a regulator to do so. It then says, in the manner set out in the license held by such a person. That's for me why I was saying it's very difficult when I read it, because it creates an impression that it's the regulator that may require a license. 1. 2, if we leave it as such, I assume that issue, it relates to the customer or end user. If we leave it as such, isn't it open to abuse, that discretion? Let's be frank and honest about some of the complaints. Today we have got legislations or policies that talk about politically exposed individuals. Let's deal with that. Will that? And I'm not saying we have not. It's something that is one-sided. When you make a law, I always say make a law that is sustainable, that can last, regardless who is in power at that stage. But I'm saying, if again I were to think from an end user, customer point of view, and that discretion is left open as such in law, will it not be open to manipulation at whatever given point? So that's why I'm saying let's deal first. My first issue, which is why I was raising it, was getting clarity who may require a license. Because if I read it, I might be reading it wrongly. And please help me, because establishing and funding a customer or end user. It seems it says the regulator may require a license. A license from who? Help me, I'm just saying, give me an interpretation of that sentence in total, because we seem to be now talking about a customer, but my reading of it seems to be saying something different. And Mylem, you want to come in before?
Yes, Chair. I think the misinterpretation is the word licensee. It's not license. It is the person that is being licensed.
Licensee, yeah.
It's not. It's so the regulator doesn't require a license. The regulator may require that the person or entity being licensed must establish and fund a customer or end users forum. So the regulator may say to XYZ company, you're a licensee, you must fund and establish a forum in terms of that.
Oh, okay, now I see it's licensee, not license. But still, isn't it a dangerous and a very risk? I would have preferred, even if we leave that to
my hand is up, Chair. Please note me.
Okay. I would have preferred, even if that was the case, that there should be some provision, something provisioning that in the sentencing, which one would say an appropriate circumstance, rather than to that discretion to be left openly as it is. Honorable Malinga?
No. Thank you very much, Chairperson. So now it means the definition that was primarily given to us, given the explanation that of the word licensee, because now I just read it as license. So we need to pay more attention to maybe to the wording. I don't understand then that the regulator may require a licensee to establish and fund a customer. How will that happen? Because if it's not the regulator who's going to fund the customer, it's the licensee. So the discretion part instead of the obligatory part, where does it fit in, so that we don't just move, Chairperson, without understanding the intention of this clause. Thank you very much.
Maybe you will help us, because just to add what Honorable Malinga is saying, let's go even up to the latter. Even if it's a customer forum, there are conditions already that are in the license. Somebody may say, does not this give discretion to comply with what is contained in the license? Because it says, in the manner set out in the license held by such a person, which for me, the person is the licensee. Do we need to be discretionary? Just explain that part. I think, to me, even if we pack it for future references, or we subject it to a proper scrutiny by the committee, at least the most dangerous thing is a feel-good decision that we can make. Just explain it for the last time for us.
Thank you, Honorable Chair. So, Honorable Chair, we did ask colleagues from NERSA to join us today. So, with your indulgence, Chair, I would ask that the colleague from NERSA, Moratti, assists in this regard.
No. There is no NERSA here. There is DMRE. So, NERSA, if it's here, is part of DMRE. We are not going to separate.
Apologies.
We are not going to separate them from you. As long as what they say you agree with them, or as long as what they say here, we take it as if it's said by the MRE.
Yes, apologies, Honorable Chair.
Yes, you can come in.
Thank you. Good afternoon, members, and good afternoon, fellow colleagues. Chair, my name is Bonisen Moratti, Acting Executive Manager, Corporate Services at NERSA. The Chair, the issue about the discretion that the regulator has the provision is implemented separate from the license conditions that are provided for in the latter part of the legislation. This is a reactive process that when the regulator, depending on the number of complaints that have been received from the customers of a particular licensee or concerns that have been raised by the customers within or end users within that particular licensee, that is when this provision is then raised to require that an end user forum be established where there will be more engagement between such a licensee and the customers or end users that are recipients of the services from the licensee. Thank you, Chair.
Okay. Can we agree to park this? It will be a subject of discussion when ourselves are dealing with the issue. Okay, can we go to the next one?
Jay, I'm sorry.
Yes.
This is a very straightforward clause. It says that the regulator may say to a licensee, you have to establish an end user forum or fund an end user forum. It's very straightforward. I don't understand what the controversy is about this. It's not like imposing on the regulator anything unrealistic. It's saying that in some instances it may require that the regulator says to Eskom or to the city of Cape Town or to XYZ company, you must establish an end user forum. But that would be the regulator's discretion whether or not they do that.
Can I appeal to you, Honorable Mele? Let me just say, for instance, for my sake, the fact that it might be straightforward to you, just be patient that the other person may take long to understand it. We don't understand things the same way. You may see it as straightforward, but we can't take it as straightforward when some people do not understand. Let's allow people their own right, even if it means people must go back and relook and restart it. They might come back to the same conclusion that you are saying, that now we are clear, we are satisfied. Can I just appeal for patience? Like I say, what you don't understand, it will be wrong for anyone to then say, no, but this thing is straightforward. The point we're trying to say is that I can tell you it will be worse if I take a note from where I'm sitting as a chair to say, no, this one, it's a straightforward thing. Then I'll be bulldozing everyone because I understand as the chair. But also, I must also think that as I'm chairing, there could be someone, if from where I'm sitting as a chair, there's something that I may not understand, or I may interpret it differently. That's why I was saying, let's agree to move forward. If members feel that there is a need to re-look at it, there is not that there is someone who is disagreeing with it now. But when we come to deal with the actual thing, whether members agree with it or not, that will be a different scenario. Okay.
Chair.
Yes,
Just check with your budget for raised heads, Chair.
Yes.
I think you're using your phone in chat. No, thank you very much. Thank you very much, Chairperson, again. I actually wanted to say, let us start this issue. We are making a law here. And we can't make a law that we don't understand ourselves. So I think I agree with your sentiments, Chair. We will come back to this. We are given a time frame to deal with this bill. So I think we will adhere to that time frame. If we don't understand something, we don't have just to rush through it. So can we be allowed to apply our minds? Thank you very much, Chairperson.
Okay, can we go to the next one? Is it 7? Ne?
That is correct, Chair.
Yeah. Any comment? I see there is a I think, is there any, that is 7.1, that 1A. Is it okay, isn't it?
I was still reading the principal document, so Mr. Arico has taken it up.
My apologies, madam.
Now, I was checking also whether is there a comment from TMR. I don't want to assume, but to me it seemed to be clear. It only talks about bases in which somebody can operate, that it requires a license according to this act or bill now for us. Is there anything that members wants to have or any express view by DMRE or public hearings that must be considered? I assume no. Honorable Mylem, you wanted to come in?
No, Chair, sorry.
Oh, okay. I'm trying to be fair. Okay. Mama Linga, are you done with reading the principal amendment?
No, I'm fine, Chairperson. We can continue.
Okay.
Thank you. Yes.
It's a 8.
Chairperson, apologies. I'm seeing the last bullet. Be involved in systems operations. Engage in system operations.
Yes.
What does that mean?
Let's read it with subsection 1. It says section 7 of the Principal Act is hereby amended by the substitution for subsection 1 of the following subsection. Subsection 1 says, subject to sections 8 and 9, no person may, without the appropriate license issued by the regulator in accordance with the Act, or unless authorized in terms of the license condition contemplated in section 14, subsection 1T, engage in system operation, amongst others. So that must be done appropriately with an appropriate license issued by the regulator. Is there any matter on 7, honorable members? Section 8. Look, honorable members, let me just say this. We just want to have that understanding of the deliberations. It doesn't mean when we go back and you come back, you realize that this I may have understood differently. We will still argue, but when we make those arguments now, we'll argue to agree in order to disagree or to agree as an agreement. Then section 8, I think, is there any comment, are there? It says the minister may, after consultation, yes. There is 8.
Not supported.
No, the one that was being proposed in the hearings. Can we go up and then see what is it? No, on the side of the department, they usually state why they are not supporting it.
On top, Chair.
Yeah, it says the advisory forum is a discretionary advisory structure that may be appointed by the regulator and, if appointed, serves to advise the regulator. Oh, okay. let's go to the principal amendment. It says the minister may, after consultation with the regulator and stakeholders in the advisory forum referred to in section 5, determine by notice in the Gazette that any activities in section 7, subsection 1 need no longer be a licensed activity from the date set out in the notice. Okay. Do you understand, honorable members? Can we then, I don't want to be seen to be rushing you. Going 1, going 2, going 3. Then 9, it says amendment of section 9 of 4, 2006 as amended. Section 9 of the Principal Act is hereby amended. The minister, I think that's where relating to import and export. I think that's the insertion that has been put, or the generation or transmission. Is there a comment or anything from members? And then you give us the version of the, if there is it any new comment from the responses of the department? I'm opening also to you, honorable members. Let's just create if we were not aware of the responses of the department. I need to have 3 pages, Honorable Malinga. You have to understand when I don't see the hands. When I look at the participants, the section of the participants, it blurs the comments from the department because of where it is located. So just remind me if your hand is up and I've not pointed at you, I don't see. It's because I must also see the column that the department is commenting on. I guess, honorable members, there's on section 9(1).
No, Chairperson, I personally need further more time on this one, because I think this is the department was responding to what was raised by the public. So I think we must consider what the public had said, because I don't think that they just themselves and giving us this proposal. I again here, Chairperson, request that we revisit this maybe in our discussions, because actually I think when we go clause by clause, if we are not doing it now, we will be faster than what we are doing now. It's just that I need to apply my mind on this one. So
No,
I request it to be packed, Chair.
That's okay. It will be similar. We are going. Yes, we might be going clause by clause, but in essence, we are doing deliberations. When we come clause by clause, we will discuss in order to agree to disagree. There will be no second bite or whatever. So let's for now we say in principle yes, subject then to members raising those issues when we deal with the clause by clause, and when we have finalized the issues of legal interpretation that still outstanding that we have not exhausted yet. But on these ones, we can move on, Ari.
Section 10, Chair.
Yes. It amends section 10 by the substitution of subsection 2 for paragraph A. It says, a description of the applicant, including its vertical and horizontal relationship with other persons engaged in the operation of generation, transmission, and distribution, the import or export of electricity, trading, market operation, system operation, or any other prescribed activity. 2, okay, or relating activity relating thereto. Any take, honorable members, or what's the version of the department on that?
We go, Chair.
Chair.
Yeah. Is that Mhlonishwa of Volmarans?
Yes, Chair. No, Chair, thanks for the opportunity, but also an apology for starting late. I indicated that I would be in transit, and I think I'm at a point where I can participate. Earlier, sorry to take you to 9, Chair, but not precisely the item. Ayato Malinga was saying that she need to check on the matter and let us pack it and so on. It's because I did not start and I don't know. If a member says no, let us pack it and we would want to discuss it to finish it. Would I be contradicting the process? Because my humble suggestion or plea was that some of the issues that you might want to pack, and I don't want to use the word that Honorable Milem used to say straightforward, but some of the issues that we want packed, we might just heap up on the packing, while we might have dispensed of the matter and then not done without getting back to it. So I would not know whether is that the line that we are taking, or can we engage or indulge in it for a moment or so.
Let me again, my understanding, for instance, Honorable Malinga says, on this matter, she would want to get a second bite, and we say because she doesn't get a full understanding, for instance, on what would have been the comments of the public. And right through, have been dealing with those issues like that. He says that give me a chance on this one to go and look for it, but he is not objecting to it because he has got no full understanding. And then we say, obviously, when you are given an opportunity to deal with clause by clause, you've got a right. Unfortunately, at that time, there will be no parking or parking. She will still be able to say, no, having read this part and understood it now, I am of the view that this is not a correct formulation. Let's consider 1, 2, and 3. It is only at that time when we make a decision, because when we do that, we'll make a decision. When that decision is made, it is then put there as what we call, like we're explaining, version A. Now, that version will then reflect what is it that we talk about. Then that's when we come back and vote on each item as now fully attached to it. At this stage, there is no objection on the actual clause that is put in front of us. So we say always there is a latitude until you finalize and polish up everything. There's latitude that members can still raise their issues. So even the last time when we were dealing with this thing, members came back and said, no, we now understand what is contained here. We don't agree with this. That is what then we'll have to go and reflect what are the general views so that when we vote on something that we understand. I don't know whether I'm explaining it better, Honorable Volmarans, but I'm open to be guided all the time.
No, it's Chair, it's from your explanation, it's quite clear, and it suffices.
Okay. Can we then, where are we? We were on 10. We were looking at what is the comment there from the DMRE.
Chair?
Anal Mailem?
Chair, I'm looking at the comments and the DMRE response, and specifically 10.1b. It says such an application must be accompanied by the prescribed application fee prescribed by the regulator. I would suggest that the first prescribed should be deleted. In other words, it should read such an application must be accompanied by the application fee prescribed by the regulator.
Can you repeat again?
So I'm suggesting that
okay.
the first
Okay.
prescribed in that sentence should be deleted. So it should read, such an application fee must be accompanied by the application fee prescribed by the regulator.
I don't think it's a transfer. I think you are correct, by the way. On I think that is amenable to it. DMRE.
Supported, Chair. Thank you.
Great. Okay. State law advisor and Advocate Jenkins.
Sorry, Chair. No, I agree with that, Chair. No problem.
Okay.
Agreed as well, Chairperson.
Yeah. If we done anything wrong, we'll put you there to do a legal representation of this committee. Okay. I'm just joking. Can we, what is 10, is it 10 to?
D, Chair.
No. Let's read the 10 first. 10 to A, B, C, D. Yes. Remember, we said, honorable members, that's why I was taking us back to where is 2?
It looks like it says the proposal is to retain the original reading of the provision of section 10, subsection 2D of the Act. So there is nothing in, so as I understand it, there's nothing here in the amendment bill. The original must be retained.
Okay, no, I see. There's something. Okay, yeah. There seem to be no major transmission. DMRE, you want to come in?
Thank you, Chair. Chair, we just probably where you were looking at, Chair, in terms of A, B, C, D, you will not see the 10.2D, but when you read under B, you'll see that it says by the substitution in subsection 2 for paragraph D.
D, yes.
So that's how we get the specific provision that in the comment section we just cited the actual section as it appears even in the Principal Act, Chair.
Okay, no, that's fine. Is there any other matter that honored members want to raise here?
Chair? Thank you, Chair. Chair, I have an issue with this in that it goes back to that whole issue of tariffs and prices that we haven't resolved yet. So I think that we should park that particular clause 10.2D until such time as we have finalized the issue of tariffs and prices.
Yes, but I thought for now here where it is contained, it takes out the prices. It says a general description of the type of customer to be served and the tariff policies to be applied. But I take the point what you say that until we resolve this issue of potential overlap or potential separation of interpretation of the tariffs and prices, I agree with you on that one. When it is resolved, we'll then be able to say, do I agree with tariffs? If on this one, whether it should be tariffs or it should include prices. Okay. Can we then go to where are we? 10G. What is it says? There's no G here. But I think the gist of it, honorable members, it's
Chair. It's not supported anyway, Chair.
okay. Can we? Oh, yeah, wait.
10 to H, Chair.
Wait, bear with me. You are doing two things. I'm doing three things. So that members don't say I'm ignoring them. I also need to check whether is there a hand raised. Then 11.
You said I must shout.
Yeah, I don't want someone who says it's sidelined.
Sorry, Chair.
Honorable Malem?
Chair, I might be way off base here, and I hope I'm not. But the copy of the Principal Act that I have does not have A to H in it. 10 to A to H. So I don't know where this is coming from. It looks like it's coming from a draft version of the bill, but it's not in the Principal Act. As far as I can see, I hope someone can clarify me, because the version that I've got has 10.2, but then it doesn't have these sub-paragraphs that are referred to here.
Before I answer for the MRE and understanding that this was a big issue, if you remember, honorable members, even on the public hearing, specifically on the written submission, the removal of that section or that clause was an issue that it's now been substituted, completely taken off when it was there before on the, let me use the word in inverted commas, on the original draft. Now, this is where we had a dilemma, because for us, we get what has been reviewed or revised post the stakeholder, I call it, those will bear with me, post the stakeholder engagement, because I don't believe there is really in-depth public hearings that are conducted, but that's fine. It's to say it's my interpretation. But can you come in and explain exactly this issue?
Thank you, Chair. The copy that we have of the Principal Act has an H which ends by saying such other particulars as the minister may prescribe.
And
Chair?
which one did send to us?
Chair?
Yeah, Honorable Malem.
Chair, I have a bit of a problem because I've looked online and the versions of the Act that are published on the government website.
Yes,
Sorry.
continue, Madam.
The versions of the Act, the 2006 original Act and the 2007 amendment, neither of them contain the reference to 10(2)A through H. So I really don't know where this is coming from. And I suggest that maybe we need to get a version of the Act that we can refer to, that everybody's on the same page. Because right now, I'm not clear what this refers to.
Demari, you want to come in before I deal with try and make a proposal?
Yes, Honorable Chair, we are emailing it to Ari just now, so that Ari can share with honorable members the correct version to look at. Thank you, Chair.
Okay. Can I do this, honorable members? It goes back to what members had requested, had said before, that in fact, even in the public hearings, this issue was raised that it is better to get the original. You see now the difficulty is that even if Parliament were to print the original, the potential that it will print the wrong version of it. I don't know which is which that we will be dealing with. Yesterday, when we were dealing with the powers and duties, just to share powers and duties, I saw another version of the powers and duties founding the founding legislation of NERSA on powers and duties. Can I request this, Dogozo and Ari, if you allow me, honorable members, let's just take not even a 5-minute break, allow this exchange, and we come back at 5:10. You? 3:10, so that we allow members to get. Let's just appreciate, if possible, just send also the correct version of the NERSA. I don't know whether we share the same view. The correct version of the act that established or establishes NERSA as a regulator of as a regulatory body. Then let's reconvene. You can just mute, and then we come back at 10:10.
Apologies, Chairperson. Before we step off, what is it that you are requesting us to do? Honorable Mayhem is raising an issue that the document that we have, there is no 210.8. So when you want us to take a break to, then what happens to the document that we've been having all along? Is that 5 minutes where you want to clarify how come we have two documents being presented to us, or two documents, even the if we do not have the document that has this clause, Chairperson, that means we've been consulting or going to public hearings with the wrong document. What happens then?
No, Honorable Malinga, we went to the public hearings on the proposed amendments, not on the original or the principal legislation, which means we did not get, that is what people were raising, we did not get the original or the principal act, the Act of 2006, to make this amendment. Honorable Mailem says what I'm having now does not have, which is the act itself that we are amending, does not have age, doesn't go up to age. But the reference here is raised to G. Department says no, what we are, that version that we are having, the version that is correct is the one that is having an age. Then we say, in as much as they are not compelled to give us the principal act, send the principal act, allow then members to say, yes, we think in that 10 minutes, in that 5 minutes, they will be in position of what the department is referring to. But there is nothing in the law that says when you amend an act, you must also send the original act. But we seem now to be carrying what is not the department is referring to, then say, send to us what you are referring to us. If then we may need to get clarity on what is the correct version. We are dealing with what the department is amending, not what we are amending. That's my understanding. And then when they have the document, we'll be reading on the same page with them. So Ntokozo says he's sending the document to Ari, and then Ari will have to send that document to us. Advocate Jenkins, you wanted to come in?
Thank you, Chairperson. Yes, I've sent a copy this morning to Ariko of the Electric Regulation Act. So I think he has it, he can send that. And I mean, I don't know resources that other people have. I can quickly go onto LexisNexis and get the NERSA Act and send that as well. But the problem we have in South Africa is that the consolidated records, the consolidated legislation, you have to pay for. That's usually in Jutastat or LexisNexis. I don't think there are many free copies of all the consolidated acts in South Africa. So I can get one off there and send it to Ariko to distribute during the 5 minutes, Chairperson.
Chair.
The department has sent it now, Chair.
Okay, then it's done.
Chair.
Yeah.
My only concern is that those be the gazetted versions of the Act. And the reason I raise that is because on the government website, gov.za, under Electricity Regulation Act, there is the Principal Act that was gazetted in 2006, and there is the Amendment Act that was gazetted in 2007. And neither of those contain the numbering 10(2)A through H. It's got 10(2). It does not have the numbering A through H. Now, my concern is that, and I'm aware of the LexisNexis version, the consolidated version of LexisNexis, but that is not the gazetted version.
Yo. Advocate Jenkins.
Chairperson, I'm trying to just save time here and explain it. I can look at it, Chairperson. As far as I'm aware, when I look at LexisNexis and how we deal with this legislation, that the Principal Act has been amended by the 2007 Act. So that is there. So what one have to read, if I need to answer the question of Honourable Malam, is to look at that gazetted amendment, because what we have in the consolidated version that is then distributed by LexisNexis is that section 9, section 10, which he's talking about, was previously section 11. And it was so if you look at the original 2006 Act, Honourable Malam, through the Chairperson, 10 would be 11 then. It was previously 11. And that was renumbered by section 16B of the 2007 Amendment Act. So if one follows that, then one can see if it is really so. And I can check that in this 5 minutes, Chairperson. But my version has a subsection 2A to H that was then previously section 11, but it's now section 10, and it's the consolidation between the 2006-2007 Acts. Thank you, Chair.
Ooh.
Those two documents, I've sent it now, Chair.
Okay, thank you.
Then will there be a need for what I was suggesting? Hello.
Sorry, Chair. I apologize for that. I was just actually reading through section 16B of the 2007 amendment. And I note what Advocate Jenkins is saying, and I appreciate the input. He is 100% correct. It does renumber accordingly. And so therefore it's very difficult to follow. But yes, it actually does renumber and create section 11 as section 10 to A through H.
Togozo. And
Honorable
gift.
Chair.
Togozo and gift. No, it may not be now, and I'm not saying it's your fault, ne? But please let's try next time, all of us, not only you, all of us, to check whether when we read, we are reading in the same page, ne? It will help so that you don't find yourself having to refer to what members I have. In fact, I think the lesson is that it now confirms also, honorable members, that even ourselves, voluntarily but also collectively, next time we must be able to get an information of this nature as a point of reference, and probably request from the department. I'm just saying, when we go, like we agreed previously, maybe when we deal with the legacy reports, we must be able to put in this, because it proved today that it is something that will help in future. So you said now, is it on 10 or is it on, oh yeah, it's no longer on 16, it's on 10. Let me check section 10 myself. Yeah, I see it on this one. It's it ends up in age. It means let's agree then that that's the version we'll be using when we need to consult on what is contained on the original or the principal act. Okay, honorable members, that's okay. Let's just say thank you for being alerted to this. Can we now go to the next? Where we are? And so Tolang and I love 5 minutes break. So we are not going to. Let's continue.
Where are we now?
All Malinga's fault.
You see, now I'm confused as well, Mr. Volmarans, because of me.
No, we were on 10. We were on 11. And then we had to go back to 10 because Honorable Maliam was raising that 10 speak of age. Now we're done.
10 to 8.
Oh, yes, we're doing now 11.
Yes, Chair.
Yes. 11. When an application is made for a license, the regulator must in writing direct the applicant to publish a notice of the application in at least 2 official languages for a period of 30 days in newspapers or other media, as the regulator may specify, circulating in the area of the proposed vicinity or activity. It then says at least 2 official languages. Let me reserve my comment until I get members. Let's get the version of the department response.
Chair.
Yes, Honorable Kaza.
Greetings to you and to my colleagues and to the respondents and everybody who is in the meeting, Chair, and the legal advisors. Look, Chair, I hear you talking about the matter pertaining to the languages, which is quite something that is very, very important, because taking into account the manner in which the hegemonic status of languages should then be taken seriously. But there's something that the law seems to overlook, Chair, in terms of the disabled person, particularly as it relates to blind people. And there is an opinion or a paper that I read pertaining to that state of overlooking those people. And there is what is called braille, which is used by those people. And you've got people that are scholars, Chair, that are really could have contributed or could still read the law when it's an act, the bill when it's I just want to check whether the legal advices have taken into account that particular instrument of the blind people. I've got a lot of oversight work pertaining to that and the complaints about the law process having to not consider braille when it comes to them, Chair. And I'm raising it so that the committee can then not pass that important aspect of lawmaking. Thank you very much, Chair.
Let me give Honorable Milam.
Thank you, Chairperson. Chairperson, my concern is that the amendment now prescribes which newspapers or other appropriate media these applications must or the notice must be published in. And the reason I raise this is it may open the door to state capture. I give you the example of the New Age, which was essentially a state capture funded newspaper and was receiving a huge amount of government funding. Now, if the regulator is given the authority to specify exactly which newspaper an advert must be published in, then it opens the door to that kind of misuse of their power.
Okay, my first thing, DMRE, please help me. Let me start with this thing. My first thing is that please assist. It might be just to augment the point that I want to put it as a consideration. When this discretion is given, what happens? Let me be frank and honest, as I usually do. If you are in KZN or you are in the Eastern Cape predominantly, or I think I must say in the Free State or Northwest, you will find probably all the official languages. At some point we had a deadlock in or some surprise in Northwest. We assumed when we were in Matrosana that there is a particular language. Now, my issue is that will it be too much if we had considered, or you consider, one, the issue of, even if you say of which one of them be the dominant. The reason I'm saying this is that you may go to a place and then I just say, yeah, here, you need English and Afrikaans. I make an example. Or you then say, no, in this area, let's take Gauteng. You go to Gauteng, you say 2 languages, it will be Zulu or Xhosa and Tswana or Sotho. And other people may not have access to another alternative language they may not necessarily be exposed to. I'm just making that example as a point of distinction. And why it is limited to 2. Is it a cost issue? or we should be considering on languages sufficiently on languages that are dominant in the area, but not less than 2. Otherwise, if we put it to 2, it's like, to me, it's a prescription. Let's go back and read it. I don't want to say it's something that you say, but to me, the level of discretion is too much. The second thing, I think, is that if we were to use 2, instead of saying not less than 3, and one of those be for people with disability, be a language of people. What do we call that thing? Yeah, I know that the sign language, it would be difficult in advert. I don't know how to do it, but like Honorable Kasa is saying, if there is prescribed and you get someone who can't be able to read but can read with brailles, and that person is deprived when it is supposed to be one of those languages. I'm just trying to, can you go back to that initial proposal on the amendment itself? You see? The original. Yes. Oh, it says at least 2 official languages. It says, when an application is made for a license, the regulator must, in writing, direct the applicant to publish a notice of the application in at least 2 official languages. I'm saying, why don't we say in at least 3 official languages, of which one of them be for people? I don't want to use, you can use whether this is a correct word to use, of people with disability, but let it be seen that there is a category that also is being considered here for the period of 30 days in newspaper. You see, now I think I get the point that Honorable Mylem says, that let's take, I don't think we should then, even there, we may have to talk about dominant or popular newspapers. I'm not sure at this day and age whether we should be really, or it says, or other appropriate media platforms as the regulator. Now, I'm not sure whether we should really have I'm making an example for me beyond that. If the regulator every day just gives the Sowetan or the Sunday Times, and in case that then you've got, what is this thing? An Eastern Cape, Isolas, that reflected dominant language, was, to me, you can't put an official language and put it in another newspaper that is not using that dominant language. So my take is that we should also find a way. I don't know, you can help if this, what I'm saying, is not appropriate, but I don't think it will be correct to have a regulator, I agree, having the authority to prescribe which newspapers, except to say those newspapers must be the dominant and something that we can call it well-read in that specific area or jurisdiction where the activity is taking place. I don't know, honorable members, that is just my take. And I think I agree that if we don't incorporate a language that we know, it may sound like, why did this one? But that's a reality. It's a language that has been disadvantaged for over a long period of time. I don't see what danger it will cause if it is catered for there. Let me take the MRE, and then I can take even honorable members who would want to have a last bite, not a second bite, a last bite. The MRE.
Chair.
Yes, Honorable Basale. Welcome to the meeting. Yes, Honorable Basale.
Thank you very much, and good afternoon to everybody. I hope my apology was noted. Chair, before we go to DMRE, ever since I logged in, you were speaking about a lot of things that confused me. And at the end, you say that is my take. But to me, there was a time where you were brainstorming in your view, I got lost on whether this is your view or you are, you will forgive me. What is your take on this matter, actually, in summary?
Let me repeat again. I'm saying that what will happen if the department considers taking a language of people with disability as a third language instead of limiting it to 3 as an official language. 2, we consider the issue of prescribing the newspapers that must be there instead of prescribing the dominant platforms, especially if it's newspapers, the dominant newspapers read in that specific area, the publication will be done. And those are the 2 things that we're asking. That can't we, instead of saying 2, we say 3, of which 1 of those be in a language of people with disability, whatever it is. 2, the publication be in a newspaper, language dominant in the area, and a newspapers that are well read in that area. So I was checking why have they considered that as DMRE, and if so, what was the limitation after members had made also their own interventions? Is that
I hear you, Chair. You can proceed to the DMRE. You said you will come back to members.
DMRE?
Thank you, Honorable Chair. Firstly, your suggestion, Chair, to consider 3 languages, we would support that. Secondly, Chair, I just want to try and attempt to explain, because from what I'm hearing from Honorable Mailem and the Honorable Chair, the interpretation of the words as the regulator may specify is being understood to mean specifying a particular newspaper, whereas it's specifying, it first says, may direct for there to be an advert on newspapers or other media as the regulator may specify. The as the regulator may specify means the regulator might specify that advertise in newspapers or through radio or run a TV ad or other media, not specifying a party or prescribing a particular, a specific name of a newspaper. That's 1. 2, the standard even on the mining side is that whenever we say the letter that would ordinarily go out from the regulator to the applicant would then say, within 30 days, advertise in 2 newspapers, one being a nationally read and another being read or dominant in that locality where you're applying. And that's where then the regulator would check that, for example, you've advertised on, on Sunday Times or City Press. Then if you're applying in Limpopo, whatever the local newspaper is in Limpopo. If, for example, it's in KZN, then you would be expected to advertise on one of the nationally read or circulating, and maybe Isoles were in KZN, for example. That's what we are referring to here, and that's been the standard. Then thirdly, Chair, I want to come to the point about dialects. Dialects are not recognized as official languages, and I'll make this example. In Limpopo, you find people who belong to the Bapedi grouping, but they speak a particular dialect referred to as Slobedu, but they read Sepedi. So Slobedu is not recognized as an official language. they speak and understand Sepedi. It's just that it's Sepedi with a particular twist. But they sure do understand and read Sepedi. Then lastly, Chair, and we admit to this, something we need to correct going forward as the department with all legislation, accommodating people with disabilities, such as Braille. Again, Braille is not a language, but Braille is a system to assist people who cannot see with the ability to read using their fingers. And that is something that we agree that we need to be conscious of.
Yeah, they go make perform rituals there.
Mama Linga, asingakuzwa thina.
Okay, so the Braille is that system to help the visually impaired to read better using their fingers. And we accept, Honorable Chair, that we must make means. And this is something we don't necessarily have to add in the body of the law, but probably in the regulations to ensure that going forward, people with disabilities or visually impaired are covered. Thank you, Honorable Chair.
Chairperson. Okay, Chairperson. Available.
Sorry, I'm talking to myself. I've muted. I'm
Okay.
saying, is there, I say, Honorable guys, is there any other member who wants to have a take? Going one, going two, going three. Okay. Honorable Kaza.
No, Chair, let's correct a misconception or misrepresentation that comes from the speaker who have just spoken now. Because I might be misrepresented as saying it's a language. I have never said that. It's on record. In Parliament here, they record things. I said it's an instrument by which it should assist the visually impaired persons. And there are a lot of visually impaired persons across provinces. You can go on statistics and retrieve that information. And there are people that can read, and the law making process cannot discriminate against such persons. And I remember we even adopted the sign language in Parliament as one of the official languages in South Africa. So part of what I'm saying is to put a law that can be accessible to everyone. And this is what forms part of my argument that as the law must be, if it's for the public, must involve and seek to cover everyone. And I'm not saying again that she's saying the law does not intend to cover. I'm saying that it can be deliberately used. You know,
you disappeared on that part. You Tobelosity deliberately used.
Yes, it can be deliberately used. I'm sorry, there are people who are sitting somewhere in some offices that decide to just call us for insurances here when we're busy with work of Parliament. Chair. And I'm sorry about that. It's really upsetting. And it tempers with our thought process here. And I was saying that it is important, Chair, to can have such interventions so that you don't have people coming to you as a public representative to present a situation in which they can read, but they do not have the instruments to do so. So that's why I'm raising the issue. Never to say it's a language or not, because it would be a different argument. Thank you very much.
Okay. Is there any member still wants to have a take? Okay, can we ask the MRE then, because I think there is a principal agreement, including all these issues. Can we then ask, I think in principle we agree that whether it's a language or not, maybe I think the DDG was referring to me, I must say on the issue of the language, but that's not what is about now. Let's agree that whether Dogozo you put it as language or what, but can we use I think Honorable Gaza says visually impaired peoples, whatever the language, can we then allow you and the SLA and the legal services to then just find a way to reformulate that to accommodate the issues that we are raising, especially in terms of the language spread. I get the point that we're raising those, but I still feel that there has to be some form of making sure what you say is what is interpreted. Once you leave a law with some degree of ambiguity, it creates those problems that from time to time, the courts then makes their interpretation of what you wrote, not what you intended on what you wrote. Can we then agree, Honorable Volmarans?
No, Chair, thanks. I just wanted to come in whilst Rutgers was speaking, but I wanted to check if it would not, but that can also be done when we do clause by clause. Instead of the 2 languages, we say 3 languages. And then we say including Braille. The 3 languages would include Braille, and that is the closest and shortest way of accommodating the people who the sign language people.
Okay, I think exactly that's what I was saying, that I'm afraid to say it's a language, but Honorable Chaza says it's an instrument, but all what we are saying is that there must be something that accommodate visually impaired people. If it means they are considered under as a third language, so be it. But I understand also, Dogozo, what you say. NgesiZulu kuthiwa language eyigodi. The point I was saying is that we have to find a way you put what is dominant in that area. If we just leave 2 official languages, all what I'm saying is that you may find sometimes those languages are not relevant in the area, and people will still say we complied with the relevant languages. Can I then, Honorable Tatu Jenkins?
Of course. Thank you, Chairperson. Chair, as I understand the instruction, we need to just add in there, in that clause 11, that the notice must also be take cognizance or must be available in language for visually impaired persons as well. As it is at the moment, in at least 2 official languages. When we speak of official languages, of course, we have the additional language now for the impaired hearing, but Section 6.3 of the Constitution deals with what you are also wanting to do, Chairperson. It says there that the government must use at least 2 languages. And it has to take into account the usage, practicality, expense, regional circumstances, and the balance of needs and preferences of the population as a whole, or in the province concerned. So it speaks to that, and maybe we can work from that, because in a word, it must be relevant. The 2 languages must be, it's always going to be English, and then a relevant other one, taking into consideration those matters. So we can either maybe cross-reference a, Chairperson, although that's not good drafting practice. But if I'm understanding it, we must just add in there a language for the visually impaired or a communication for the visually impaired, then, Chair, if I understand you correctly. Thank you. I just need some clarity on that.
Yes, that's why we said go back and do what is legally sound and what is legally permissible. If you have to do cross-reference, for instance, to say, as prescribed in section sorts of the Constitution, I'm not saying that's what you must do. Just put it must be legally sound, and it must be able to stand legal scrutiny in generations to come. I think that's the point that some members were raising. I think Honorable Malinga was raising the same thing, that when you make a law, it must stand the test of times.
Thank you, Chair.
Okay. Can we go to, if members allow me, can we go to 12, ne?
Correct, Chair.
Is there a comment from the department?
Not on the document, Chair. No.
Okay, is there a comment from honorable members? Going one, going two, going three. Okay, let's go next. On 13. Thirteen. Is supported. Where we are.
There we go, Chair.
A bit up. Yeah. Oh, you ran away again. Is it the one? I think it says it's supported, and therefore the proposed amendment is that the regulator must make a decision to grant or refuse an application in the prescribed manner within 60 days. Is that the only part? Instead of 120?
That's the only part, yes, Chair.
Honorable members, let me check. Any take? Going one, going two, going three. So the turnaround time is 60 days. Okay, let's go. We are... There we go back again. On D. Honorable members, let me check. Is there any take? Going one. Going two. Going three. There is a proposed on 14.1, no, what done? 14.1G. It says provide that the regulator make any license subject to conditions relating to the regulation of the revenues of licenses. This is a discretionary power that may be. So I think the interpreter, that issue is just an illustration of what is the base founding authority. Any comment from honorable members? Okay, going one, going two, going three. Can we go to, was it 14I? There is no comment, it's a retention. Next one, Ari. On the original, I think we are going to close to subsection section 15. Yes. What's the comment here on the other side? We take where it says the regulator when not this, the regulator when subjecting a license to conditions relating to the setting or approval of prices, charges, rates, and tariffs charged by licenses. Okay, it says it's not supported. Any take on our members? Going one. Going two. Going three. The next one, Ari. Where are we now? Any comment on 15 as a whole, honorable members? Before we pass. Okay. 16. We are on 16. There is 16. We won't limit honorable members if they want to have a take. But 16.2 is supported. Let's see, what is it? Are
No, it's just supported and welcome, Chair.
I see only the
It's the change from the minister to the regulator.
okay. Welcome back, Team DMRE. We didn't even notice that he had disappeared for a few seconds. Um, 17. What is contained there, Ari?
Seventeen 3.
Yeah. There's
Insert
a
a
proposal
new
to insert a new section 17.2a, which reads the regulator may, if it is alleged in terms of section 18, subsection 1, read with section subsection 3d, or on its own assessment, revoke a license if a license has contravened or failed to comply with a license condition or any provision of this act. I think that one is a little is understandable. Those are conditions of reviewal or revoking of a license, or empowering clauses. Can we go to, I'd say that that's the section 17. Any comment on this one, Ari? I see that there's a replacement again of the minister. And his or her. That seems to be the main issue, but that does not mean honorable members see it as such. Any matter that honorable members wants to raise, that is
Chair.
Honorable Mailam.
Chair, could we just slow down a second, because I'm trying to keep up, but I'm cross-referencing and trying to read the original act and the proposals and the amendments and the responses, and I'm really struggling to keep up a little bit. And I apologize for that. Could we go back to section 17 for a second?
Yes.
So the current act, as I understand it, has at 17.1d that regulator may revoke a license on the application of a licensee if conditions of a license are not met. That's on application of a licensee. Then in the responses, we've got a proposal to say that a new 17.2a, the regulator may, if it is alleged or on its own assessment, revoke a license if a licensee has contravened or failed to comply with a license condition or any provision of this act. Chair, I just have an issue with whether or not there is sufficient due process in 2AA. In other words, the regulator may, if it is alleged that there is non-compliance. I'm just concerned that it doesn't give sufficient opportunity for both sides of the story to be heard, or for a fair process to unfold in that regard.
Okay, I get your point. Any take, honorable members? Or DMRE?
Okay.
The fact that, yes, Honorable Malinga?
Apologies. I think it's almost the same issue as the issue of the regulator on the licensee I don't want to respond for the department on the discretion part of it. But this time around, because there could be a sanction that could be imposed, I would like to believe that the regulator will have on your terms and conditions that when you break this could be the penalty. But maybe the department could clarify. Remember when we were dealing with that section, I think it was 9 or 7 or 8, I can't remember. I'm lobby to go to the beach, so okay. Yeah, that's what I wanted to say here.
Okay. I think the point, Honorable Malinga, where it makes a distinction, this one is based on allegations. It's not based, if it was saying, let's go back, I think it would have been, if it has been found or whatever. Yeah, now it says if it is alleged. Now, the assumption at the conclusion, I think that's what Honorable Malinga is saying. The assumption on the conclusion is that even if your license is revoked, it could be revoked on the basis of allegations, not on the basis of a due process that will then conclude the allegations that there is some degree of fact on the allegation. I don't know, but the MRE, can you clarify the issue? Because it says in terms of section 8.1. But the point is that your only point of determination seems to be the allegation, not a proof of an act of contravention.
Thank you, Chair, and thank you for the question from the honourable member. Chair, if you read section 18 of the Principal Act, provides for a process wherein the regulator, if it receives there's an allegation of contravention or failure to comply with license conditions, it may sit as a tribunal to decide on the allegation. And then there's a process that the regulator must implement. And then in terms of the founding legislation of the regulator, the National Energy Regulator Act, Chair, Section 10(1)(d), the regulator is enjoined, Chair, that every decision that it takes has to be taken within procedurally fair processes that wherein affected persons have the opportunity to submit their views and present their cases. So the consensus of a process that must take place, that must comply with natural justice processes is integrated when we read these provisions together with the obligations of the regulator in terms of the founding legislation.
Okay, I think also, I hope I got you on. I think also the point is the subsection B also tries to address the issue and say on its own assessment, which it means now on its own assessment as a regulator, then revoke a license. If a licensee, it means now we set the conclusion of that assessment. If a licensee has contravened or failed to comply with a license condition, it means, like it says, that subsection 3(a)(d) and then kicks in order to come at the conclusion of what precedes the revoking of the license. I'm not sure whether I'm adding something that makes value. Honorable Mailem?
Thank you, Chairperson. Chairperson, I take note of what the DMRE are saying, but Section 18, so for example, 18.1 says, if it is alleged that a licensee has contravened or failed to comply with the license condition or any provision, the regulator may sit as a tribunal. Then in 2, it says, if the tribunal finds, it may serve a notice on the licensee directing them to comply, as the case may be, within a reasonable period. 18.3 says, if they fail to comply with the notice, they may sit as a tribunal. And then it says, if they find that they are, it may issue a penalty. The problem that we've got in the proposed wording of 2A is that it doesn't say that the regulator must sit as a tribunal and find that they have breached the it just says if it is alleged, then it may revoke the license. And I'm concerned that I think, first of all, that this should sit under 18 rather than under 17, and that it should also be worded in the same format as 18.1 and 18.2 and 18.3 and 18.4. In other words, you say, if it is alleged that then the regulator may sit as a tribunal. If it finds that the allegation has substance, it may then revoke the license. I think it would just go to consistency throughout the document. Thank you, Chair.
Sorry, DMRE, I see your hand.
Thank you, Chair, and thank you, Honourable Member. Chair, just maybe probably to bring this up front, because if it's not, we are not yet there, but when you get to the next proposal, there's a proposal that is being made under 18, and one of the proposals is exactly as the Honourable Member had been referring to, because we had made a proposal that talks to the tribunal if finding an allegation that is contemplated to be correct, then there are proposals of a process flow that the regulator may have. One of them being imposition of a penalty, recommending the amendment of a condition, or the revocation of a license. So the proposed insertion in the upcoming Section 18, Chair, are also intended to ensure that these gaps are linked together, Chair. But when you read this together with the National Energy Regulator Act, any decision, because to revoke a license is a decision, that legislation requires the regulator to undertake that in compliance with the Constitution and all the administrative processes that are prescribed by law. Thank you, Chair.
Let's check here. If this section, I'm just asking, 17, were to be a section that stands on its own, what will it be called? I look at, for instance, some section will be conditions of revoking a license. And now I'm just saying on the issue raised by Honorable Milem, that isn't it this supposedly, just guide me, supposedly then to be a reflective of an outcome of an allegation that has been made and proven. And therefore it means either it be renumbered to either 18 some point something or 18.1, and then because it seems for me, even the intention is the ultimate end of an allegation, and it comes before the process that must be followed to prove the allegation. I'm just saying, I'm just having a wild mind to reflect on this, whether by location it is appropriately located where it is. I'm just thinking out loud. I don't know, anyone who wants to have a take on this. Reordering is very important when it comes to the legislation. For instance, probably at the conclusion, it says any early license can be revoked. But where it says it may have a license to be revoked and a penalty imposed, what penalties could be imposed is located somewhere else. DMRE?
Thank you, Chair. In terms of location, Chair, it has been located under Section 17 because Section 17 deals with revocation of license, and it had provided only for revocation of license on application. So the only time that a license would have been revoked would have been on application. So the proposal to place it under Section 17 is to introduce second circumstances where there are allegations, not necessarily not on application by a licensee, or whether the regulator has made its own assessment. So it's an empowering provision that empowers the regulator and provides the circumstances under which it may revoke. And then Section 18 is a process. When a revocation now has to be undertaken, then Section 18 prescribes a process. It's a process. Section 18 is a process. Section 17 is the circumstances that can lead to the process. Thank you.
Okay. No. Honorable Madam, then I will try and...
Thank you, Chair. Chair, I just want to suggest that Section 17 be renamed Revocation of License on Application, and Section 18 then deals with contraventions, because you've got a revocation where there's a contravention in terms of the license conditions, and that typically would fall under Section 18, whereas the current Section 17, as you rightly say, is about where the licensee says, I want you to revoke my license. So I think that by changing it to revocation of license on application, and then 18 is where you would then say where there's a contravention of license, we now have a process where the regulator can revoke a license because it's been contravened. Does that make sense?
I think isn't it what is contained currently?
But it's written like that, Chair.
I thought you were saying revocation of license application. What is it? Where there has to be then reflect on potential control. It's fine. I think it is 17, except if you read it from amendment and what the department is saying, but 17 says revocation of a license on application, which then says is a contravention. Can we then agree that if that's what is needed, can we then allow the team to look as to, but I think the general gist and content or context is what is agreed upon. Can we go to 18? Eighteen deals with revocation and deregistration. Mm.
Eighteen deals with contravention, Chair, from the document that Mr. Kotse put up. I think when you're reading from the amended version, if Mr. Kotse can put that one. When we were looking at 17. The one you were opening, Mr. Kotse, was the correct one. That the chairperson, I want him to read the topics now, so that we don't get caught.
That's what it says. It makes reference to the revocation and deregistration.
Chairperson,
As
when
the section 17A, subsection 1.
There's somewhere where there is contravention, Chairperson. I'm not sure which document is it, because we have a lot of documents now.
No, this is the one that the department said. The one we are amending.
Go down on this one. Go to 18 on this one. You see, contravention of a license on 18. It's what I'm telling you, Chairperson. So on the amended version, I think it's the revocation. Yeah. I think you must have this way now as the chair, so that we don't get confused.
We're working with this document, ma'am.
Can we go to what is there a comment of the department on this? Because I thought generally, even when we were before we arrive on it, there was no big issue except the issue which we may look at it was the ordering, if I were to use that word. Beside what the department, it seems the department does not have a big issue, but members we can't limit. I see DMRE, let me start with Honorable Milem, and then DMRE.
Sorry, Chair, I was struggling to unmute there. Chair, my issue is, and I have no problem with 17A as proposed. I think it goes a long way to addressing exactly the concern that previous comment was trying to address. Okay, but I do think that we need to bring in the provisions that are currently in 18 of the Principal Act. In other words, if you go to the document B23 2023, it just says the regulator may vary, suspend, or remove. So I would suggest that we bring in some of the wording from 18, where we say, if it is alleged that a licensee has contravened or failed to comply with a license condition or any provision of this act, the regulator may sit as a tribunal to decide on the allegation. And then the regulator, on finding that such allegations are sustained, may amend, revoke, vary, etc., etc. All I'm saying is that it just brings in that bit of process ahead of the regulator having this unfettered power as it currently is worded. So before the first part of 17.1, I think that we need to say the regulator sitting as a tribunal must find the allegation to be sustained. Thank you, Chair.
Okay, let me not come in. Let me take, before I come to DMRE, I'll come to you, Honorable Malinga.
No. Thank you very much, Chairperson. We said we will refrain, or would rather not use may but must. If a contravention has been found by the regulator, by the licensee, the regulator must. You see, I think we're making a law, Chair, that the law that needs to be abided to. So if we say it's like you put a regulator there that cannot deal decisively with the person who may decide to revoke their license and whatnot and whatnot. So the way I think I hear what Honorable Malem is saying, but the regulator must be given powers to after investigating to deal or issue a sentence.
Yo, and Ma'am Temari, please help me again as a chair. Is this section suggest an amendment that must be put on the Principal Act, and therefore the conditions or the circumstances on the Principal Act will still stand because they are not a subject of amendment? And then this reference to section 17A subsection 1, because I think when you look at what the Honorable Malinga was talking about, when you look, if I'm correct, on the original or Principal Act, it talks about contravention of licenses. But when you come here, that section 18, nothing is reflecting except the reference to section 17A, which is, let's go back to it now, which is what we are told we must amend, which is an amendment. I assume this amendment, unfortunately, that's why I'm saying, please help me, now is reflected not as 18A. This amendment is reflected as a revocation and deregistration. But when you look at the original, it talks about the contraventions. I'm not sure whether I understand. Please, just be patient with me to be specific, to understand what is the meaning. Because there we are coming, like Aries, we are coming from 17, we are going to 18. When it says the following section is hereby inserted in the Principal Act after section 17. So section 17, that's what I'm trying to say, should be talking about revocation. Just help me to understand that, also that part from what honorable members have raised. The MRE.
Yeah, thank you, Chair. Chair, maybe just to try and explain it in terms of a sequence, Chair. Section 17. Section 17, Chair, deals with revocation of license. And then, Chair, in totality, the part of the amendments talks to the issue of dealing with registrations, because there's been an exemption that has been done. So there was no process for dealing with registrants or people who have registered in terms of should now they default or should they do certain things. Then the regulator was not empowered to address them. So the proposal to insert section 17A, Chair, is to deal with revocation and deregistrations. I think our error, Chair, in terms of probably not making this clearer, was that we should have said revocation and deregistration of registrations. And then the grounds that are proposed under section 17A applies to registrants. And then the powers that are listed in 17 plain are talking to licenses. And then the 18, because it talks about contraventions, and honorable member profiled it properly in terms of contravention of licenses, because it was dealing with a process and a procedure for revoking licenses. That's why it was a process that was linking to 17. And the proposal for the process to either become applicable also to the revocation and deregistration processes, then we may need to also either link it to 18 to also apply to registrations and deregistrations in terms of the process, Chair. But I hope that clarifies why you find 17A being slotted in between 17 and 18 of the Principal Act, Chair. It's just to deal with revocation and deregistration of registrations. Thank you, Chair.
No, Chair. I think maybe Mr. Ntapo did not get what Honorable Mailem was saying. We're not disputing, I don't think that is disputing what the intention of the clause says. But the chairperson here, now he's explaining something different. We were on the wording of what what clause 18 must say. So Yena he's explaining that previously there was not this and not that, and yeah, I think I'm not sure whether he got what the Honorable Madam was saying, because he even read from the document. I am disputing the word may and putting must on what he's saying.
I'm trying, Gift, to understand in law, what is it that could be in between sections in the law? Is this section under 17 as it is stated, or is it under 18? Because you say now it must be inserted between 18 and 17 and 18. And what we have here is 18, but 18, when I look at the amendment in its totality, when it says amend 18, it then brings in 17. That's why I said, explain for me from a lay person who doesn't understand these technicalities. And it's a different, and I think that's the point also that Honorable Malem was raising, and you are trying to explain. It's a different heading on the original or on the Principal Act. This one is on revocation and deregistration, but the Principal Act is on contravention. That's why my issue for me, it's a technical issue. If it is immaterial, that's okay. Honorable Volmarans?
No, thank you, Chair. Chair, the question that we have just asked, I was also contemplating on it. But Chair, if you look at on just above, when we deal with 17, it is quite clear that the section 17 of the applicant is of the Principal Act is hereby amended, and the amendments there are stated. And in order to deal with the question of revocation and deregistration, you have 17A. After 17, and maybe it might be a misprint of some sort, but I think it must be the 17, and we come with 17A, then we come with the 18 that we have just been speaking about now, as we explained. Otherwise, if you have this 17A where 18 is, it does not talk to each other. But if you have the 17 and on addition, with regard to revocation and deregistration, you have the 17A, it therefore makes sense. And then 18 must be something separate, which speaks about itself, Chair.
Yeah. Jamari, I saw you wanted to come in. I don't know. We may find a way.
Go ahead. Thank you, Chair. Chair, I think maybe for...
Wait, sorry, Honorable Mahlaule.
Sorry. I just wanted to have a view on what you just said, that we may need to find a way. I thought that Honorable Volmarans has just given us a way. Let's please consider that way. I don't think it's a way out just for the sake, but it makes more sense to do it the way he is suggesting. Thank you very much.
Okay, Honorable Jemari.
Thank you, Chair. Chair, I think maybe once I hear the honorable member, but maybe because we were about to make the point, let me make it in any way, Chair. I think, Chair, and we hope that the state law advisor is supposed to have come in and really provided this clarity, Chair. In terms of drafting and the prescripts that they prescribe for us when we amend, the numbers that 1, 2 up until where we are when Chair you are saying 18 there, that 18 is a number that does not refer to a clause in the bill itself. It's a number that would have been coming from when we started with the first inputs consequentially until the end. The actual sections that gets dealt with becomes the part that says insertion of section 17A, and then when it says the following section is hereby inserted in the Principal Act after section 17. It is just by chance here that it sits as 18 there. It could have been 10 or 9 or 8. So the numbering that we are following 18, 19, 20 on this side is not necessarily directly related to the number of the clause in the bill itself or in the Principal Act, Chair. That was just the clarity I just wanted to probably explain in terms of the numbering and the flow of the numbering. But to answer the question that you sought clarity on, 17A, in terms of looking at the Principal Act, comes after 17, section 17 of the Principal Act. So we are proposing to insert A17A. And then it will be the normal clause 18, Chair, which the honorable member was proposing that probably the process that is prescribed in 18 needs to be repeated for this process here, so that there's a procedure to deal with these revocation and registrations that are provided for under 17, the proposed 17A. Thank you.
The state law advisor or legal services, I will come back to you, Honorable Mailem, and then Honorable Volmarans.
Chairperson, if I can put a little bit onto the table on this matter, if I may, unless the state law advisor needs to go first, Chair, through you.
Up to both of you.
Okay, no, thanks. I'll just give my input, Chair. The way of inserting the 17 capital A is a well-recognized method, and it saves us from having to change all the numbering of the Act after we've now inserted the new clause. So this is a standalone clause with its own heading. So that's drafting convention, Chair. There's really nothing untoward in law in drafting legislation like that, especially when well, not especially, but specifically when we're amending legislation. One looks at the tax laws, the Income Tax Act, and so on. It's quite a few alphabets that actually goes around there, because that act comes from 36. So you get a lot of ABs and AAs and ABBs there already. So of course one must limit the, Chair, but I'm just using it as an extreme example. So that is in order, Chair. I just wanted to make a quick comment about the use of may or must. In general, is correct, as the honourable members have indicated. The must is peremptory, that must be done, and the may is empowering, and it leaves you the options. One must just be a little bit careful when we are not giving an obligation. We're giving a power here. We're giving a power to a regulator to impose or to take certain action based on a certain set of facts. So to say that regulator must do something it runs the risk of putting that regulator into a corner when there are certain circumstances where he might have taken, or she, or the body itself, taken a different approach. So I would argue that in that circumstance, may is the correct word to use, to say that the regulator is empowered to take the following action based on a certain set of facts, especially when there are various options that are given. So must will be almost forceful, too forceful there. Regulator, which one must I take? So it could be confusing to put must there, Chair. That's my input on this one, Chair. Thank you.
Okay, Honorable Mailam.
Thank you, Chair. Chair, I just want to make a proposal on how we deal with this going forward, this particular issue. So I want to suggest that we park it for now, clauses 17, 17A, and 18, and that the DMRE consult with the state law advisor and look at a consolidated way of drafting that accommodates all of these things in an appropriate manner. Because as it stands right now, there's 17, which is revocation on application. Then there's 17.2A, which was supported. Then there's 17A. Then there's 18. And they kind of overlap each other. And I think that it just needs to be cleaned up a little bit in order to make it all make sense. And I think that if we park it for now and let them come back with a cleaned up proposal, we will go a long way to addressing the concerns I have, the concerns Honourable Vormerans, Honourable Malinga, Honourable Mashwale, that we all have with regard to these three sections of the Act. Thank you, Chair.
Honourable Vormerans.
No, Chair, the hand that you saw was the previous legacy hand, Chair.
Okay, so what's the final conclusion, honourable members? There is a request that let it be packed and then be refined and then be put back to the committee for decision.
Agreed, Chair.
Thank you very much. Can we, so it means are we dealing with 18 or we passed 18? Oh, by the way, we're on 18. Okay. 19. Is there any comment by the department on license renewal? It seems there is none. Is there any comment that members wants to have? Going 1, going 2, going 3, okay. Let's go to or 19. Oh, now there's numbering. There is renewal of license. Let me just deal with that. Renewal of a license. Cool. The department's comment is that any generation, transmission or system operation license issued in terms of this Act is valid for a period of 20 years or such period as the regulator may determine. That's what is the proposed refining of the, instead of 15 is 20 years, instead of longer, it says for such a period as the regulator may determine. Any take, honorable members? Going 1, going 2, Going 3, okay. Is there any, let's go, Ari, on the original, but there seem to be. On 21, there seems to be no support on some of the.
I think, Chair.
So in essence, there are no proposed changes. 21, can we go then? Let's go, Ari. Okay, the amendment on section 22.
Okay.
Honorable Malinga.
I was reading this section where you said, I think it's section 21, because now I after the explanation, I no longer want to read the numbers. Let me read the sections. Chairperson, the last part, is it legally correct? Because we have legal people here. That a transfer or assign any such power or duty to any other person without the prior written consent of the regulator. If I want to transfer my license to maybe my daughter, I need a regulator's approval. And how long will that approval take? May it's just for clarity's sake, Chairperson, not that I'm against it.
Well, on 21, Ari. I'm trying to check what section, but I don't want DMRE.
20, section 21.
Let's go to 21, Ari.
And there's 21.
He is at the right place, Chairperson. It's amendment of section 21, Act of 4, which number is 20, section 21 of the Principal Act is hereby amended. I was reading the last line, which is 40, I think. I think that's number 40, yes. I just wanted to Chairperson. Yes, thank you, Mr. Kotse. I'm just asking for clarity, Chairperson. Why does it have to be the regulator that gives me a consent to transfer or assign my license to why, and how long will that take? Just for clarity's sake, Chairperson, not that I'm against the line that is there.
In simple terms, we want to have a basis of argument if it is agreed to understand the rationale behind it.
Correct, Chair.
Honorable Mailam.
Chair, my concern is with the new 4C. If you can scroll down a bit, please, Ari. Keep going. Keep going. A little bit further. So it's under G, 4A, 4B, 4C. There we go. Chairperson, my concern is this, that it talks to a party requesting information on network capacity and measures that would be necessary to reinforce the network, and that any party that requests that information would be responsible for a reasonable fee, maybe charged a reasonable fee. My concern is that there is no obligation on the network operator, whether that's the system operator or the market operator, to maintain an up-to-date record of that information.
Okay.
So I think, Chair, what I'm saying is that there needs to be a line that says a transmission or distribution licensee must maintain an up-to-date record of network capacity and measures necessary to reinforce the network. Thank you, Chair.
Okay. Is there any other member? Going one, going two, going three. Dear Mary?
Thank you, Chair. Chair, the reason why the regulator would need to also provide consent when a licensee wishes to transfer or give their license to somebody else is that that license would have been initially issued by the regulator to that specific licensee. And the regulator needs to also have oversight, regulatory oversight as to whether the license that is given over to somebody else, the person who has to receive the license, there must be due diligence as well, that the regulator satisfies itself if it is appropriate for that person or the person has the capacity and all the requirements that for them to maintain or keep that license or to take it over. So that is why it is required that the regulator must provide that consent. And then on the proposal, because it's a proposal that is made around the insertion of keeping of or maintaining of up-to-date information, I think the department would support that.
Okay, then you will reformulate it to accommodate such. I'm asking with
So, Honorable Chair, it will be the Oxlade team. Of course, we will continue to support.
exactly, that's my point. As long as it's not necessarily like it's what you are proposing, let me put it like that, and what was being proposed, that's okay. That team then will do the necessary work. Legal services is listening and is taking responsibility to bring us legally sound reformation. Okay, is there any other matter, honorable members? On the
why do I need the regulator to transfer and how long will that take?
He did answer, but I think he didn't answer the part of how long did that take. If I'm not mistaken, I may not be putting it in verbatim. The answer was that the license would have been issued to a specific person, and that specific person would have been given some specific license conditions, and amongst those, the issue of the transfer will have to be also a subject of a due diligence on the person who the license will be transferred to, including a determination on the issue of performance and capacity. I think that's what was said. But DMRE, you'll have to give your version whether that was the answer. But yes, I agree with you. The issue of the time frame of that process, how long it will take to do the transfer. Will it be the same with the application? I think that's the question that also has not been answered. When I give you the MRE or whoever from yourselves, including the state law advisor and legal services.
Thank you, Honorable Chair. Yes, that is the the response. And maybe if I may make an example that will probably sound familiar. Section 11, in terms applications that come through in terms of Section 11 of the MPRDA to cede a mining right, for example, to a mining right holder from a mining right holder to a new entity. There is that requirement that you bring that Section 11 application, because before we issued that mining right, we would have asked for example, financial capabilities to run the operation. We would have asked for rehabilitation and guarantees or provision, that type of stuff. So similarly here is that approach to say the regulator needs to satisfy itself that if we had licensed X under these conditions and they met all the requirements in terms of their financial capabilities, etc., operational, technical capabilities to operate a facility or facility, the person to which now they are seeking to transfer the license has the requisite capabilities. And then on the time issue, it's really an administrative issue with the regulator. And the standard is with transfers and sessions, the process usually isn't longer than a new application altogether, because it's really a due diligence issue. Thank you, Honorable Chair.
Chairman. I hear what DDG Ngwabe is saying. You know why I am asking for a time frame. Remember, I like it because he refers to the mining sector and whatnot. There is a time frame to apply for the license to get a response. Why here? They don't have a time frame. If I may, I know that there's your 14 days, your 30 days, and yeah, why they don't have it here? Because if they say it will depend on the regulator, what if I want to do this now, they respond at this time next year? That would have taken me the whole year to transfer my license. So why are they not putting the time frame like they do with them in the mining sector? And yeah. Thank you, Chair.
Okay, Jamari, you can answer. My understanding is that I don't know, but maybe help on the issue of the Section 11. But the time frames that I know, especially are on exploration in terms of acknowledgement of application, which is 14 days. I think here, if I'm not mistaken, in terms of the application period, turnaround time, which we just, if I'm not mistaken, agreed on was 60 days instead of, was it 150 or so on application. But you can help with regards to the transfer or exchange with regards to Section 11 in the MPRDA.
Okay. Thank you, Honorable Chair. So usually these applications don't take longer than 3 months, Honorable Chair, because it's not like, as you correctly put it, it's not like those longer time frames for new applications. Thank you, Chair.
But he's asking, is there a time frame on Section 11? Let me put it like that.
Unmute. No, Honorable Chair, there isn't. No, there isn't. It's okay. we just apply PAJA and they can literally take a month as soon as everything that is required has been submitted. All the technical capabilities, financial guarantees, as soon as all those are submitted, then there is no question. Thank you.
Let me then rephrase what Honorable Ndinga will be asking probably. What harm it will do if we were to consider to place a time frame on the transfer? I'm just asking a wild question.
So, Honorable Chair, I think it wouldn't harm us to stick to the 60 days that we've set for ourselves anyway.
On transfers, not on application.
Yes, Chair. Yes, on transfer, Chair.
So that's something that as this committee, it must consider itself. Okay. We got it, Honorable Malinga. Susviti.
Chair.
She's disappeared. Honorable Valmarans.
Chair, I think on that question of time, I think all the others seems to have been answered. But on the question of time, my honest view is that, and I'm not holding a brief for the department, it would be unfair to place a time frame on this type of application where I want to seed or it needs to be seeded or I apply to transfer and so on, save for the fact that there is an insertion that deals with section 14 already that talks about all the other conditions that were given to this previous owner, so to speak, which must be complied with. So the owners rest on the administration of such transfer and no date can be attached to it. It's unlike applying for a new license where the dates must be, we are going to approve it, it's a fresh thing in 30 days, in 60 days. But here where I want to sit to whoever or there's a request for me to transfer, the conditions are best left for that May that we had said the regulator might exercise on giving even extra conditions. If the financials are not in order, you will have to go back and check all the other matters. So it would be not fair to put a specific turnaround or date on a matter of this section, Chairperson.
Okay, I got it. That's why I was asking the MRA, because I don't know, some of the license conditions may, in terms of Section 11, go beyond even the control of the department, because they might require the approval even of the Competitions Commission and other. I'm just saying intervening external circumstances that may not necessarily fall under this. But I think it's a matter that I take note, Honorable Volmarans, that when we deliberate, we'll have to take into consideration the consequences or the effects of putting a time frame and not putting a time frame on the transfers. I think it's a duty that is on our shoulders, and we must be able to justify either of the choices that we'll have made. Can we then, where are we now? You're on 22.
Yes, Chair.
Is there any take, honorable members, or let's look at what is there any comment from the MRE or?
Nothing, Chair.
Nothing. Any take from honorable members? Going 1, going 2, going 3. Okay. Oh, now I see. Okay, now I see.
Even myself, Chair, I'm seeing now as well.
Yeah, I see now. My eyes are open. Yo, I don't wish for any person this thing. We were on section 20. Let's go up. We're on section 22, né? There's nothing. Then there's on section 24. Amendment of section 24.
Nothing, Chair.
Members, is there any take on the amendment of section 24, proposed amendment on section 24? Okay. Amending section 27. No issue. Any take, honorable members? Going one, going two, going three. Amendment to section 30. Is there any take, Ari, from the
Sorry,
department?
Chair.
Honorable
Chair,
Malem?
I couldn't unmute. I apologize. 27. The amendments that were proposed from the floor or from the public have not been considered. They were supported, and that was it was that it be to the department responsible for local government, for provincial and local government.
Isn't it what is proposed there, Ari? You think it's jumping? Where is it, Gene? It says regularly reporting and providing information to the department responsible for provincial and local government, the National Treasury and the National Regulator, and customers.
Yeah, Chair, my point was, and I'm sorry, I might have blanked out, but I understood that you were accepting the amendment.
The original amendment.
Yeah. And
it's the inclusion of the word responsible for.
Yes.
So instead of
that, it's still the, yeah, I think that's what now it says, Honorable Malem, you're correct.
Thank you, Chair.
Okay. Let's go to, we were on
27.
We're done with 27. This
Now,
one
yeah,
that
Chair.
we just amended. We're going to 30, the amendment on section 30. There's 30.1. That's what I see here. Ari, go back. There's 30.1A and section 32.
But it's not supported, Chair.
Yes, that's what I'm saying. I want members. Okay. In fact, it seems the entire...
Except the last one, Chair, 30, subsection
30.3. Is there any other matter except subsection 3 of 30, honorable members? We will come to, so that I don't lock you out. Okay, there is a section, it says that the regulator must prescribe by a rule the procedure to be followed in a mediation and arbitration and the fees to be paid.
So it's the inclusion of those three words, Chair, by a rule.
Okay. Is there any take, honorable members? Okay. Let's go. We are on 32, ne?
Yes, Chair.
What does it say on 32? Before we go to members. It's not supported. Honourable members, any take on 32? Any subsection or clause? Going 1, going 2, going 3. It's in section 33. Is there any comment, Ari?
Not supported, Chair.
Can we go to this 33? Is it, yeah, 33. Let's go up, Ari, to page 14. Wait. Why that I see, if let's say, maybe you will clarify me, if conducting this work, it must be seen to be transparent, open. How do we reach the question of a confidential, I say personal, a confidential, if it is related to the regulator or commercially sensitive, except if we say it's not related to, but will that clause not be open to, may use the word now that I have, to secrecy? If it says, let's go to A, R, AR. You see, A says, by the substitution order, at all reasonable times, enter any property on which any activity relating to the supply of electricity is taking place or is suspected to be taking place. To inspect any facility, equipment, machinery, book, account, or other documents relating to the electricity fund there at. And let's then go to B. Let's say it says no information obtained by the regulator in terms of this act, which is non-generic. I get non-generic. I hope I understand it. Then where it says commercially sensitive or confidential or proprietary in nature, sensitive or proprietary nature may be made public or otherwise disclosed to any person without the consent in writing of the person to whom that information relates to, except in terms of an order of the court. Can you explain to me, especially to this committee, in its oversight powers, duties, and authority? Honorable Mylem?
Chairperson, I want to agree with you because Section 10.2 of the National Energy Regulator Act specifies that any information relating to a record of decision or any decision made by the regulator is public and must be made publicly available. And it does not limit that to non-generic. It does preclude personal and commercially sensitive information, but the rest of those categories do not fall within that ambit. And it really makes obtaining information, for example, in the form of a PIA application, very, very difficult. I'll give you an example because this is something that I did in the last month. I submitted a PIA application on the National Energy Regulator for the record of decision and the related documentation regarding the nuclear determination, the 2,500 megawatt nuclear determination. The response I got from the regulator was that they were not the owner of the information and therefore could not make it available to me. Now, just on a legal basis, that's wrong because they are a public entity and they are in control of that information. And in terms of the PIA Act, they have to give it to me. But this is actually sidestepping PIA by saying that they need to get consent in writing of the person to whom that information relates. I think this is going way too far in terms of secrecy, Chair.
Is there any take from honorable members before I go to TMRE? And by the way, in fact, we must start with the state law advisor. If it had gone through this, to have an understanding what informed that decision. Is there any other honorable member wants to come in? Going one, going two, going three. Okay.
Yeah.
Honorable Volmarans.
Taking cue from what Honorable Malem just, I beg to differ a bit because in terms of your application for access to documentation, if the documents do not reside with yourself, it's not your documents, and you have signed confidentiality clauses, you have submitted personal and confidential matters. If the regulator then goes and publicly give them to a third party, within the law, it is not necessarily acceptable. So I would err on leaving this as it is because the consent of the owner of such information is important. Otherwise, you go to court and get consent through a court order. But where the information is not already public, we need to be careful on how it is being obtained. Even when you go forward to the question of where you appear in court on documents, there is an aspect of whether the information that you are putting in front of the court, which is personal, whether it's a cell phone or whatever information that whoever might have found it, if no consent was given, there is always a dispute on how it was obtained and if it is admissible and correct in court. So I would rather err on leaving this as is, and I'm also interested on what the law advisor would say on the matter.
State law advisor and legal services before TMRE can come in.
Chairperson, and the way that the proposed subsection 4, section 33(4) is worded in the bill, it does provide for the regulator to first obtain the written consent of the person involved before such information is published. It does give that option, but it's also geared towards protecting the commercially sensitive and personal information of the party involved. So that option is given to publish the this type of information, provided that the written consent is obtained first. So that does appear there. Thank you, Chair.
Legal services.
No, thank you, Chairperson. The provision as it's worded, Chair, seems to dovetail a bit over the Promotion of Access to Information Act. I think if we unpack that provision, or when we unpack it, so this is information obtained by the regulator in terms of the Act, which is, I assume, files and files of information to issue licenses, applications, as well as then the transfer and so forth. Now, the Promotion of Access to Information Act, in any event, would require that you obtain the, if there's personal information or commercially sensitive information, that you obtain permission before you disclose that. I just tried to look now, Chair, into the Promotion of Access to Information Act, because if I'm not mistaken, there's a superseding clause in there, or prevailing clause, which says any act that is in conflict with the Promotion of Access to Information Act will not prevail over the Access to Information Act. Because what I'm reading here, it doesn't say that if that person if the person doesn't give consent, then you have to go to court order. That's what this provision says. But if there might be instances, for instance, public safety or commission of a criminal act and so forth, where you don't have an option, you have to disclose that information. And this provision doesn't seem to cater for that. So one will have to, if I'm now going to court and someone wants this information, it wasn't given, I will look at the Promotion of Access to Information Act and see whether there are not provisions there that overrides this one. So I think the question, Chair, and I didn't have time now in the half a minute when we started dealing with this to see how does this subsection 4 relate to the process and the grounds for refusal in the Promotion of Access to Information Act. I'm not sure if the department has, I assume they have done that cross-referencing and check when they drafted this bill, Chair. But yeah, that's my input for now, Chair. Thanks.
Okay, Jeremy. I see your hand, Honorable Melem.
Thank you, Chair. I think, Chair, just to explain this provision, the starting point is that in terms of the NERSA Act, National Energy Regulator Act 40 of 2004, NERSA has to, or the regulator has to perform its functions in compliance with the Constitution and the prevailing laws. And some of them talks to the promotion of protection of information, and that is the critical basis of making this provision to say that the protection of information prescripts all require that a person whose information you must disclose must grant consent. So that being the starting point, Chair, the provision then is not an open-ended provision that says any information, then it has the categories of information that aligns with your access to information and commercial information that is considered to be sensitive, so that it requires that consent, Chair. So that is the starting point of it, and that is the basis for including that, because, Chair, we cannot expose the regulator to activities where it may be opened up to legal challenges on them violating the prescripts of the law that the Energy Act requires them to uphold, Chair. So that is the basis for this, Chair. So any proposals then we'll have to consider if they are being made to change this, Chair. Thank you.
Okay, Honorable Mele.
Thank you, Chairperson. Chairperson, I think that there needs to be a lot of work done on this, because I think that the understanding that is being displayed by the DMRE is severely lacking. Let me start by saying that PIA has got some very specific prescripts as to what can and cannot be made publicly available. The whole of Chapter 4 provides what mandatory refusals can be made, and some of those are information held in confidence, etc., etc. However, in the National Energy Regulator Act, in Section 10 of the Act, it says, and I quote, every decision of the regulator must be in writing, must be consistent with the Constitution and all applicable laws in the public interest, It says, based on reasons, facts, and evidence that must be summarized and recorded. And then at 10.2, it says, any decision of the Energy Regulator Act and the reasons therefore must be available to the public except information that is protected in terms of the Promotion of Access to Information Act. So it's already covered. We don't need it in the Electricity Regulation Act because it's already in the National Energy Regulator Act. And if it's not in the National Energy, if it's not covered by PIA, then it should be publicly available. And we can't now use the Electricity Regulation Amendment Bill to bypass PIA. That's what I'm saying. That PIA is very, very specific. It's been tested in court. We've gone through numerous instances where people have applied for information. It's been rejected for various reasons by the courts or approved for various reasons. And we can't now try and second guess that or circumvent it through this piece of legislation. My point is that this is already covered in the National Energy Regulator Act, and we shouldn't try and do another or somehow amend that in this amendment bill. Thank you, Chair.
Can we go back to section to A? So that if we agree to go and rework. Look, I thought subsection A enables the regulator to, or authorizes them to make those interventions. If I were to attend to this, the limitation is that in being enabled, it's not, don't want to use the word prescribing, it's not dealing, which is where my issue is. It doesn't seem to be dealing with the regulator. It seems to be dealing with the third party. And that is why I'm saying, let's allow, including considering what, for me, whether it won't be easy summary to say, no information as prescribed in the in section so and so of the powers of the national regulator will be could be made public, something to that effect, so that it shortens the verse. But my main worry is it could be different if this bill, like I say, you don't need a situation where you take a bill and it goes to court and gets challenged that it is acting contrary to an existing law. And the PAJA has always been one of the, I may use in inverted commas, weakest link, that the act is not compliant with that particular act, and therefore that act proceeds. And I must say, my treading with caution is exactly that. Now, when I look at what this on A, what it authorizes the regulator to do, enter any place at whatever, blah, 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 all those things, and it discovered that information. And then somebody says, no, that information is very sensitive, is personal, I see, and it doesn't give grounds on the side. It may be interpreted to say literally, if somebody then raises an issue of being personal, commercially sensitive, and so forth, you then, instead of doing what you think you can be able to defend, because then there should be a provision that, in my view, even if it's not reference to PAJA, that what will be the purpose of entry? If it is not prescribed on A that they can only enter only for information that is for their purpose and license conditions, then we understand, even if that issue, I may not be saying what Honorable Volmarans and Honorable Milam says, but where the issue is on what basis the information cannot be made available, but it's not stating what are the powers and authority that the regulator has over the information and what it will be looking for. In my view, I would find it very odd if the regulator is looking for a relevant information on the performance of his duties according to license condition, and then it takes my personal information, put it in the public and say, this is what we've discussed, which is completely irrelevant to the execution of its powers and authority. That is why I'm saying I look at the conditions that it cannot happen, but can I leave honorable members to the legal services and because I think even yourselves in terms of consistency, it's gonna be the issue. If all of you agree that what is formulated here, it must remain as it is. Let's keep that reservations that we are having on the basis of what we are legally giving us as a basis. But I'm very skeptical when powers and the basis of the I will say arbitrarily entering a place and then interpreting of the relevant information for the authority must be left to the individual who is a subject of that intervention and uninvited intervention. And I think that is where my limitation is. It seems to me to be protecting more the person who is a subject of that unsolicited intervention or entry. DMRA or Honorable Milam and
Chair, sorry, before you continue, Chair.
Yes.
Look, this meeting was scheduled till 5 o'clock, Chair. We're supposed to start at 6 o'clock with the
6 o'clock. Okay.
NNR amendment bill, Chair.
Okay, let's just dispose of this and then we'll be done.
Chair,
Honorable, in 2 seconds, and then I'll go.
Yes, Chair. Two things. First of all, it's not PAJA, it's PIA, the Promotion of Access to Information Act. And as I said, PIA has some very specific exclusions on which you cannot make that information public. One of those is public information. But the second issue that I wanted to bring to your attention is that this particular amendment says no information obtained by the regulator in terms of this act. It doesn't specify that it's information obtained by them going on the premises. It's any information obtained in terms of this act. So it could be you submit a report to the regulator, or you submit an application that contains a whole lot of information to the regulator. That's information obtained by the regulator and is then covered by this particular clause. So I think this clause is a lot broader than you think it is. And I think that PIA does an adequate job of protecting personal and confidential information. We don't need this. It is redundant and it goes too far. Thank you, Chair. Oh, sorry, Chair. Before I leave, I really would ask that we get a legal opinion on this particular clause in relation to Section 10 of the National Energy Regulator Act, read with PIA. Thank you, Chair.
Okay. Advocate Jenkins, then DMRE.
Thank you, Chairperson. Let me just get my things together here, Chair. Section 6 of the Promotion of Access to Information Act. Oh no, sorry. Section 5. Section 5 of PIA, or the Promotion of Access to Information Act, provides that the Act applies to the exclusion of any provision of other legislation that prohibits or restricts the disclosure of a record of a public body or a private body and is materially inconsistent with an object or a specific provision of this Act. So that's the clause that the section I was looking for in PIA. And basically, with the application of that, if the department, for instance, or the regulator refuses certain information based on subsection 4, then one can go to PAIA and get it. So PAIA will supersede this provision. And Chairperson, I wanted to say the same thing as Honourable Malam, that the word "this act," any information obtained by the regulator in terms of this act, because that it caught me when I did the first input on this matter a few minutes ago. Any information in terms of this act is not just when you enter on permission to look on certain information on that premises that is either suspected or that deals with electricity supply or reticulation and so forth, Chair. So I think the outcome of that, Chair, PAIA will prevail over that provision. And I think what needs to be done is maybe just to see if PAIA, you can't get around PAIA with this provision. Let me put it to you that way, Chairperson. Thank you.
Thank you, Chair. Chair, the comments are noted. And then, Chair, the other part, I think that we will be guided by that opinion. But, Chair, having gone through Oxley, if there were any constitutionality around this provision, we believe that they would have been picked up. And the interrelationship of these provisions with the other provisions may very well mean that you may have recourse to PAIA or to PAJA or whichever other legislation, but it does not mean that this provision is inconsistent with them or unconstitutional with them. Critical importance. There are other national key points legislations that talk to the protection of that information that relates to those areas. If they come to the hands of the regulator, then these provisions are there. But a critical part, Chair, you had characterized it properly when you viewed it in one angle. But another angle, Chair, when you read the provision, it also says towards the end, this consent, it must be of the person to whom that information relates. It may very well be a scenario that the regulator enters a premise, finds information from a licensee that relates to party B, and then the regulator cannot disclose that information without that consent of party B if it would have found that information under the custody of a separate person other than the person to whom that information relates. If we are looking at this from the person to whom the information relates, then all the approaches that the consents come up. But if this information relates to another person, not the actual directly involved person, then this provision also plays a key role in protection of that information. Thank you.
Chairperson? Okay, sorry.
Yes, Honorable Mahlaule. Honorable Mahlaule.
Can you hear me, Chair?
Yeah, I'll hear you now.
Yeah, I wanted to say, Chairperson, that let's welcome that there's a suggestion that we look for a legal opinion. But I thought that you would really caution us that we are not dramatic when a legal opinion comes and we don't agree with it or it doesn't agree with what we think. And I'm raising this because we've had a legal opinion from Parliament where a person representing Parliament legally was told they are wrong. And then when it's a different color, they are correct. We've had that situation. And I want to caution that, let's say we are going to get a legal opinion, whether it's delivered by this color or that color, it must be a legal opinion that we trust that it serves the purpose of the committee. I just want to remind you, Chair, that we have had these incidents where legal opinion had a color before, and we should not continue to have that. Let's agree we're going to have a legal opinion and agree to stick on that legal opinion. Thank you.
Honorable members, DMRE, let's start here. I think I don't want us to enter your space. We have discovered this now. We are requesting you that you go and meet, like you say, that it might have slipped through the Chief State Law Office of the State Law Advisor. That's fine. Unfortunately, we can't resolve it now, including Advocate Jenkins. But like the two other opinions that are still outstanding, that we are still going to deal with them, that we have commissioned, we want you to go meet and be able to harmonize. I don't want to go on the areas that you have raised because it will reopen another discussion. You go and harmonize, because just as a by the way thing, that unsolicited visit, I'll make an example. If it discovers that between me and you, and as me as a license holder, I'm colluding with you, I'll find it very odd that then I must consult someone who is a suspect. I can only inform you, but to then say what we have discovered, we must then get your consent. That's to me very dangerous. The second thing, I think it will be wrong for us as lawmakers to make a law that will be subject to interpretation and a determination by the judiciary, because people who can decide what is legal or not legal, what is constitutional, not constitutional, is the judiciary. It's not our purview. But every law, that's what we make. We must make it watertight. We can't create a law and say, if you don't succeed, if this is how it happens, you will then go to court and get a court order, because that would have been a judgment. That is, we are saying, make even that it be determined from the point of decision. And I think that's the issue that must drive us, and make it a point that it is compliant with the requirements, and not leave it to open interpretation by the judiciary. I think that's the issue. I take the point, Honorable Marshal, one of the things I always say is that when these issues happen, let's deal with them at that moment. I can safely say any matter that is brought here, one, the decision finally rests with us. Thirdly, as we have said, we must have a justifiable reason why we may not accept what we are legally advised on. My understanding is that when that legal advice is presented here, it's not about questioning the legal advice, but is to make the political content that is required, because at the end of the day, you are the lawmakers. So I can assure anyone that in the final analysis, for me, is to make sure that we reach a conclusion that will be in line with the proper legalities. But if there are any undertones, we will have to deal with those as and when they prevail and be able to move forward. On that note, honorable members, I know it has been a hectic thing. Ari, you will bear with me. Can we agree that we are adjourning now? Let's meet again at 25 past 6. Thank you very much.
Fine, Chair. So the next meeting on the ERA is next week, Tuesday, Chair? Physically in Parliament, yeah. Yeah.
No one is going to complain. Thank you.
Thank you.